With Alexia Alanis.
Alanis is a
Ellie.
right. So we're on the record in docket 2402863. That is people the state of Michigan versus Alexia Alanis.
Alexia Alanis.
Alanis. Thank you. This is the time set for a preliminary examination today. Will the parties please introduce themselves for the record? Ms. Tepper.
Of course, Your Honor. Assistant Prosecutor Abigail Tepper, appearing on behalf of the people.
Mr. Etheridge.
Morning, Your Honor. Attorney Derek Esposito, the public defender, on behalf of Ms. Alanis, who's standing to my right.
And ma'am, you are Alexia Alanis, is that correct? All right, thank you. This is the time set for preliminary examination today. Ms. Tepper, how are we proceeding?
Your Honor, defendant has agreed to be screened for the 55th District Court Mental Health Court program, which would result in an adjournment of today's date. Both myself and victim advocate and Assistant Prosecutor Joel Martinez has spoken with the victim, and that is something that we are all in agreement to have done.
All right, I noticed, so is this a request for an adjournment, or is this to be, are we going to waive? What are we doing here today?
Your Honor, we are requesting an adjournment for that screening to take place with the 55th District Court.
All right, and Mr. Etheridge, is that a fair statement? I've noticed that we have a good cause adjournment last time, so I'd be seeking a waiver of the 21-day rule.
Yes, Your Honor. All
right, may I inquire of Ms. Alanis of her waiver of the 21-day rule in order to adjourn to get screened for the, it's the 55th drug court?
Just mental health court.
Mental health court.
Yes, Your Honor.
All right. Ms. Alanis, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Derek Etheridge. He would be here to cross-examine any witnesses or cross-examine any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish today to waive your right to a prelim only within that time period. You wouldn't be waiving your right to a prelim in general. You just be waiving your right to a prelim within that 21-day period, so you can get screened for mental health court. All right, that's all we're doing today. We're not gonna waive the prelim in general, just within that 21-day period. Is it your wish today to waive your right to a prelim only within that 21-day period?
What do you suggest? Yes.
And Ms. Tepper, the people are also waiving the right to a prelim within 21 days?
Yes, Your Honor.
All right. I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made to the 21-day rule. So that's been waived. And then do we have some time frame as to how far this should be adjourned out?
Your Honor, I'm typically in front of Judge Hillman out in 55th, and that process usually takes about 3 to 4 weeks.
All right. So like a month, take 4 weeks.
That would be sufficient. 3 and 5.
Let's go 5, just in case.
December 5th at 8:30.
So December 5th at 8:30 for the adjournment for screening for mental health. And you have that date, Mr. Etheridge?
Yes, Your Honor. That's a PCC date, correct?
Correct. That would be a PCC date.
I said in the prelim, do they want PCC?
Do you want a PCC or
PCC would probably be fine, Your Honor. They assume that she's going to be entering in the middle.
That would be my assumption.
It's on a PCC day.
Let's put it on. Let's call it a PCC on a PCC day.
Okay. Same thing.
So PCC, same time. We'll just relabel it to a PCC. Anything else for the record in 2402863? That's been adjourned to December 5th at 8:30. Ms. Tepper.
No, Your Honor. Thank you.
Mr. Etheridge.
No, Your Honor. Thank you.
All right, Ms. Alanis, you'll be back here on December 5th at 8:30. So that you should be screened by that time period. All right, ma'am?
Okay.
You're all set. Thank you for your appearance today.
Thank you.
Derek, do you have that information? Okay, just want to make sure you have it.
I'll copy it. I'm not sending it.
Thank you.
Oh.
And where are we going next, Ms. Tepper?
I believe Attorney Shepherd is ready with Philip Barham.
Philip Barham is a PCC.
It is, Your Honor.
All right, so we're on the record in docket 2402-611. That is people of the state of Michigan versus Philip Barham. Will the parties please introduce themselves for the record?
Good morning, Your Honor.
Ms. Tepper.
Assistant Prosecutor Abigail Tepper appearing on behalf of the people.
And Mr. Shepherd.
Good morning, Your Honor. Eric Shepard here on behalf of Philip Barham. We're both in person in the courtroom, and Mr. Barham is standing to my right.
And sir, you are Philip Barham, is that correct?
Yes, Your
All
Honor.
right, thank you. This is the time set for a probable cause conference. Ms. Tepper, how are we proceeding?
Your Honor, it is my understanding after speaking with Attorney Shepherd that there is discovery outstanding from the defense to the people. And so I would ask for an adjournment of today's date for us to receive that discovery.
I indicate that the waiver of the 21-day rule was previously made on October, was signed. So it is signed, stip and order and waiver was signed on October 4th.
That's correct, Your
This
Honor.
matter. And then, all right, so there's discovery outstanding. Is that a fair statement, Mr. Shepherd?
Yes, Your Honor. You signed an order for early return of subpoena. You signed the actual subpoena itself, and then there was the attachment to the subpoena. So you signed those documents in October. I served the documents to Richard Harris, who's the complaining witness in this case, via email and via first-class mail. Mr. Harris did respond to the discovery demand and court orders by sending me an email on this Monday, November 4th. I've emailed that to my client. It's a 195-page PDF. I emailed it to my client. He's in the process of reviewing it and looking it over. We're trying to see if it's responsive to the subpoena. The initial thought from my client is that it's responsive to one of the email addresses, and there's 3 or 4 email addresses for Google Calendar records that were from those associated with those email addresses. And so we're just in the process of still getting the responsive documents, and then obviously getting it over to Prosecutor Wilson and going back and forth, email exchange and phone calls with respect to continued discussions and negotiations about this case.
All right, and what time frame are we looking at in regards, and I know Ms. Tepper, you're covering for Ms. Wilson. I would think 3 to 4 weeks.
I would ask for the December 5th for PCC, and then an exam date to be scheduled either on the 12th after that, or if the court just wants to do a PCC, that's fine by me.
Let's start with just a PCC, and what date do we have for PCC? Because I want to make sure the discovery is all set before we actually set it for prelim. And what are you anticipating if we had a prelim? Witnesses would be at least, this is an embezzlement case, so
It'd
it's a paper case.
It'd be probably 1 or 2 witnesses, but it would
Take a little while.
take a while.
Fair statement, Ms. Tepper?
It is, Your Honor.
All right. So let's set the PCC first.
December 5th.
All right, so we'll adjourn for continuing negotiations and discovery for December 5th at 8:30.
Thank you.
All right, so we've adjourned this for as indicated previously for discovery and continuing negotiations for December 5th at 8:30. Ms. Wilson, I believe, is on the case, on this case, as Mr. Shepherd knows. Anything else for the record in 2402-611, Ms. Tepper?
Nothing for the people.
Mr. Shepherd?
No, Your Honor, thank you.
All right, Mr. Barham, we'll see you on that December 5th date. Thank you.
Your Honor. Thank you.
Next, Ms. Tepper.
I believe Attorney Austin is ready with Eric Hurd's review.
All right. I did see the report on that. Mr. Austin, how are you?
I'm well, Your Honor. How was the court today?
Pretty good, pretty good.
I don't know if he is. I don't see him.
So is Mr. Hurd joining us?
He should. We asked for him to be put on.
Yeah, I'm sorry.
Is that him from group series or?
No, that
I
is-
believe is Mr.
That is not him.
Don't know that he was put on Polycom. We asked for it.
They might be just waiting for the gentleman in the post to be cleared out first.
Right. It was set for 8:30. Mr. Austin, do you want to wait to see who's in post?
I don't.
Sir, on Dominic's iPhone, would you please identify yourself? On Dominic's iPhone, would you please identify yourself? Are you Dominic McKinley, sir?
Yes.
Okay. Group series seems to think they're muted. I don't, that's what the officer said. I don't know. We seem to be able to talk to everybody but the group series.
Group
I don't
series
know
is
if
Walter
it's-
Luther Psychiatric Hospital with Joseph Laney.
Okay, yeah, we're gonna call that case in order, but we do have Mr. Leany here. Thank you. Mr. Leany, can you hear me?
Yes, I do.
All right, stand by. I'm gonna call some cases in front of you. So
All right.
what's going on, Mr. McKinley?
Yes.
All right, so we're on the record in docket 24-03273. That's People of the State of Michigan versus Dominic McKinley. Will the parties please introduce themselves for the record? Mr. Pfeiffer
Yes, good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
and Mr. Austin.
And good morning, Your Honor. Jared Austin appearing on behalf of Mr. McKinley. He appears with us today remotely via Zoom.
And sir, you are Dominic McKinley, is that correct?
Yes, sir.
All right, and you can hear me all right, Mr. McKinley?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. Mr. Pfeiffer, how are we proceeding?
Your Honor, the people are prepared to proceed for the preliminary examination. We'd ask to be left on. There is no offer at this time. I've spoken with Mr. Austin earlier this morning. I believe that his office just appointed to the case yesterday, but we do not believe there will be any significant delays in discovery that would require an adjournment. But I have told Mr. Austin, if that becomes necessary, to let me know.
All right, so it's my understanding, Mr. Austin, that this is being left on for preliminary examination, and then you'll let Mr. Pfeiffer know if there's some type of request for adjournment.
That is correct, Your Honor, and I've spoken to Mr. Pfeiffer about that as well as Mr. McKinley. I don't want to disrupt the timeline at this point unless it's absolutely necessary. Mr. McKinley was going to retain his own counsel. That fell through. He reapplied with our office and I was appointed to represent him yesterday afternoon. So at this point, I would ask that it be left on, but if for whatever reason, there's some significant delay in either the receipt of the discovery or it's rather complex and voluminous that would require me additional time to review it, I would let Mr. Pfeiffer know that, and then I would be requesting an adjournment next week on that if necessary. But for now, I would just ask it to be left on to see if we can receive the necessary discovery in the timely manner.
All right, Mr. McKinley, so this is going to be left on for next week, November 14th, which is Thursday at 9 o'clock. That'll be live in person on the 6th floor of City Hall, unless you hear differently from Mr. Austin. All right, sir?
Okay.
Anything else for the record in 24-03273, Mr. Pfeiffer?
Not from the people, Your Honor.
Mr. Austin?
Nothing additional, Your Honor. Thank you.
All right, we'll see you on that November 14th date at 9 a.m. Thank you for your appearance today, Mr. McKinley.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Pfeiffer.
Thank you, Judge. Have a good day.
You too, Mr. Austin.
Claim my folks out there.
All right, Mr. Leany, we'll call your case. So we're on the record in docket 24-00694. That is People of the State of Michigan versus Joseph Leaney. Will the parties please introduce themselves to the record? Ms. Tepper.
Assistant Prosecutor Abigail Tepper, appearing on behalf of the people.
Mr. Freeman.
Yes, Your Honor. Stephen A. Freeman, Assistant Public Defender, appearing on behalf of Mr. Leaney, who appears by Zoom, I believe.
And sir, you are Joseph Leaney, is that correct?
Yes, sir.
All right, you can hear me all right, Mr. Leaney?
Affirmative. I hear you correctly.
All right, thank you. This is the time set for a forensic review today. Ms. Tepper, how are we proceeding?
Your Honor, I have reviewed a letter from the Center for Forensic Psychiatry indicating that defendant is still incompetent but restorable, and I would ask that the original order continue.
And is that a fair statement, Mr. Freeman?
Well, it is a fair statement in the sense that the gentleman is currently in a process of attempting to be restored to his competency, but the second evaluation did indicate that he continues to be. And if I may, Your Honor, with the court's permission, I'm looking in particular at the psychological abilities associated with competency to stand trial, which is on the last page, page 3. Court submitted to the court and to counsel from Dr. Durand. In that paragraph, Your Honor, it is striking to me that it almost smacks of criminal responsibility. I believe it would be in my client's interest. I will submit a proposed order to the court for an examination as to criminal responsibility. He seems not to be aware of any of these proceedings.
I believe competency is the only request made right now, correct?
Yes.
That's my understanding.
And criminal responsibility would be a circuit court, would be a circuit court issue more than a district court issue.
I just thought in light of this,
right.
It seems to be a smack of.
Because I don't know if you can make the motion, but I don't know, once he's deemed incompetent, he can't do anything, right? And he's yet to be reviewed as incompetent. So that would be my concern. My concern is that once he's in the process of being restorable, but he's incompetent to do anything else. So that's my understanding. That would be problematic.
I understand the court's point. Other than that, I don't disagree with counsel, but the report does indicate that they're hopeful of restoration with continued treatment.
Right. The report does indicate, and that I'm indicating that report does indicate that restoration is in the process, that he's incompetent at this point, but restorable to stand trial. I'll of course entertain any motion, but it might be problematic here, considering that he's still in the process of being reviewed for competency at this time, or being restorable at this time. He's incompetent. So I will sign the order indicating that we have a continuing order. I'm just trying to find out, there's a statutory time period of 15 months as he's waiting. He is in review right now. So I'm asking for a review date. What's the review date? Yeah. Because I think we're looking about 60 days out. That's what we've done.
The other one in January.
All right. So I don't want to lose track of it, of course. So let's set it. So I'm going to sign the order just in case. I find, based on the report provided by the Forensic Center, and then somewhat the indication that the people requesting an adjournment in this matter for restoration. The defense has indicated that there may be a criminal responsibility motion, but they are indicating they did receive the letter, they read the letter, and they're not in objection to the letter at this point. I'll find that the finding for order and competency concerning this matter for today's date, and I'm signing the order of competency, and we will reset for 60 days out. January 10th at 8:30. So we'll reset for January 10th at 8:30 for a review on the competency restoration issue. And then we will make Mr. Leany available by Zoom. He's still there. Okay.
Your Honor, may I trouble the court to indicate to Mr. Leany that if he is released, would he please contact me upon his
Right.
release?
Right.
Thank you.
And
will.
what is the facility he's at right now?
Havenwood.
I don't remember.
Havenwood.
I think it's in here.
He's at
Walter
Havenwood.
Luther Psychiatric Hospital. Walter Luther.
Okay. Can you say that again, ma'am?
He's at Walter Luther Psychiatric Hospital in Westland, Michigan.
Thank you.
Mm-hmm.
So he's not at that. All right. So, Mr. Leany, if you are released, you must contact your attorney, Mr. Freeman, in regards to this. We've reset this for January 10th at 8:30 for continued review on your restoration status. Anything else for the record in 24-00694, Ms. Tepper?
No, Your Honor, thank you.
Mr. Freeman?
No, Your Honor, thank you.
All right, Mr. Leany, we'll see you on that January 10th date. Thank you for your appearance today.
And I also have to ask a question because here I see Department of Department of Health and Human Service, which lead by Elizabeth Hartel, Director, and also the government of Michigan is led by the Gretchen Whitmore. So these
All right,
two
Mr.
has to go together, and I have to be with them.
So, Mr. Leany, you should make that all available to your attorney, Mr. Freeman, all right?
And I have to go home. So and people who live with me here, they also Saturday they have to go home because they need to go home. And that's why I have to wait for.
All right, so we're on the record in docket 24-03266. That is People of the State of Michigan versus Rennie Porter. Will the parties please introduce themselves to the record? Ms. Tepper.
Assistant Prosecutor Abigail Tepper, appearing on behalf of the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Porter, who is present and standing to my right.
And sir, you are Rennie Porter, is that correct?
Yes, sir.
All right, thank you. This is a time set for a probable cause conference. Ms. Tepper, how are we proceeding today?
Your Honor, I am here covering for APA Abigail Wilson today. She indicated to me before she was off that she intends to file an immunity petition in this matter. And so I would ask for an adjournment of the probable cause so she may do so when she returns next Monday.
Ms. Schroeder, did you have any discussions with Ms. Wilson concerning this matter?
I had not heard so we would be objecting to the adjournment.
All right.
I did not hear until Ms. Tupper got a hold of me yesterday about this. This case has been pending since about the 29th of October.
Arraigned on October 28th.
The 28th, and from what I understand, the petition is a fairly, I guess for lack of a standard petition, that's what I've been told. I don't understand why we need to have a further delay for Mr. Porter for that when this is something that should have been known to the prosecutor at least a week ago at this point. So we would object.
All right. Well, it seems like we can leave it on for preliminary examination, and then Ms. Wilson come in, and you can in the meantime, if Ms. Wilson is able to get you the immunity, negotiations will continue on the case. And then we'll readdress it at the prelim, but we'll leave on for preliminary examination. On November 14th at 9 a.m. you'll let Ms. Schroeder, you'll let Ms. Wilson know if she needs witnesses or not. If she does need witnesses, it's left on and we're going to prelim. If there's any expected negotiations or consultation about sir, did you want to say something?
Yeah, my name is Roy.
Why don't you step outside, okay? No, sir, why don't you step outside? Yeah, before you go to jail.
They should just go to school and stop trying to get me.
You should go outside. Yeah, that's a great idea. We'll see you. Thank you. Thank you. Thank you. You're all set. All right, so Mr. Porter, we will leave on for prelim on November 14th at 9 a.m. Ms. Schroeder will keep in contact with Ms. Wilson.
I mean, I'll just say, Your Honor, at this point, we plan on having the exam that day. I mean, that's what I'm going to be preparing for. So I would say that she's approved for witnesses.
All right, so this will be set for prelim and it's going on November 14th at 9 a.m.
Thank you, Your Honor.
Anything else for the record in 24-03266, Ms. Tepper?
No, Your Honor, thank you.
Ms. Schroeder?
No, Your Honor, thank you.
All right, Mr. Porter, we'll see you next week, November 14th at 9 a.m. Thank you for your
Yes, sir. Thank you.
Your Honor, before the next case is called, could Ms. Wanji and I approach briefly?
Sure.
Once you're feeling better, let's take time to come in.
Judge, we're not muted, just so you know.
Oh, thank you.
Yeah, at least a little bit, yeah.
Mr. Uberoth, so Mr. Uberoth, you are in jail post 2, is that correct?
Yes, sir.
Okay, all right, so we're on the record in docket 24-03261. That's people of the state of Michigan versus Scott Uberoth. Will parties please introduce themselves for the record? Ms. Tepper.
Assistant Prosecutor Abigail Tepper, appearing on behalf of the people.
Mr. Goodrich.
And Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Uberoth, who's appearing from the Ingham County Jail today.
All right, and sir, you are Scott Uberoth, is that correct?
Yes, Your Honor.
And you can hear me all right, Mr. Uberoth?
Yes, Your Honor, again.
All right, thank you. This is the time set for a probable cause conference. Ms. Tepper, how are we proceeding?
Your Honor, it is my understanding that we are leaving the matter set for preliminary examination next week.
Is that a fair statement, Mr. Goodrich?
Yes, it is, Your Honor.
So we'll set for prelim and leave on for next week for November 14th at 8:30. So, Mr. Ubroth, we've set this will be left on for preliminary examination on Thursday, November 14th at 8:30. Anything else for the record in docket 2403-261, Ms. Tepper?
No, Your Honor, thank you.
Mr. Goodrich?
No, Your Honor, thank you.
All right, Mr. Ubroth, you're all set. We'll see you next week at 8:30.
Thank you, Your Honor.
Next, Ms. Tepper, or Mr. Goodrich.
Mr. Butterfield, Your Honor.
Mr. Goodrich is more aware of where his clients are.
Well,
than us.
yes, and that's fair. All right, Mr. Butterfield's on Zoom, I believe.
Yes,
So
sir.
we're on the record in docket 2403-217. That's People of the State of Michigan versus John Butterfield. Will the parties please introduce themselves for the record? Ms. Tepper.
Assistant Prosecutor Abigail Tepper, appearing on behalf of the people.
Mr. Goodrich.
And Attorney Luke Goodrich from the Public Defender's Office, appearing for Mr. Butterfield, who's appearing over Zoom today.
And sir, you are John Butterfield, is that correct?
Yes, Your Honor.
All right, you can hear me all right, Mr. Butterfield?
Yes, sir.
All right, this is the time is set for a probable cause conference. Ms. Tepper, how we proceed?
I understand that we are leaving the matter set for preliminary examination next week.
Is that a fair statement, Mr. Goodrich?
Yes, it is, Your Honor.
So we're leaving on for November 14th at 8:30. It'll be next Thursday. So Mr. Butterfield, we'll see you next week, November 14th at 8:30. That'll be live on the 6th floor of City Hall of Lansing for your preliminary examination. Anything else for the record in 2403-217, Ms. Tepper?
No, Your Honor, thank you.
Mr. Goodrich?
No, Your Honor.
All right, you should be all set, Mr. Butterfield. We'll see you next week.
Thank you.
Thank you. Mr. Goodrich, who's next?
Jeremy Parker.
We did have some cases here. Look at that. Missed the list. All right, so we're on the record in docket 2403-210. That is People of the State of Michigan versus Jeremy Parker. Will the parties please introduce themselves to the record? Ms. Tepper.
Assistant Prosecutor Abigail Tepper, appearing on behalf of the people.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Parker, who's standing back to my right.
And sir, you are Jeremy Parker, is that correct?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. Ms. Tepper, how we proceed?
Your Honor, we are leaving the matter set for preliminary examination.
And is that a fair statement, Mr. Goodrich?
Yes, it is, Your Honor.
So we're leaving on for preliminary examination for November 14th at 9:30. So Mr. Parker, that'll be live on the 6th floor of City Hall, Lansing. You're set for November 14th at 9:30. You should receive notice from my court officer, all right?
I had a notice too, Your Honor.
All right, thank you. Anything else for the record in 2403-210, Ms. Tepper?
No, Your Honor, thank you.
Mr. Goodrich?
No, Your Honor.
All right, Mr. Parker, we'll see you next week at 9:30.
Thank you.
Take care, Mr. Parker.
It was more,
Oh, okay.
it was more habit than anything.
You said it, sorry. Okay.
As long as he has notice, we're good.
Thomas Bruce.
Okay.
No.
That is correct.
Okay.
Mr. Bruce is not here.
Drop the whole square, sorry. Yeah, let me do one quick yell in the hall.
Okay.
Just to make sure he's right.
Just to make sure.
That's wishful thinking.
All right, so let's go on Mr. Bruce. All right, so we're on the record in docket 2403-294. That is People of the State of Michigan versus Thomas Bruce. Will the parties please introduce themselves to the record? Ms. Tepper.
Assistant Prosecutor Abigail Tepper, appearing on behalf of the people.
Mr. Goodrich.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Bruce, who has not appeared today.
All right. This was scheduled for 9:30. It is now 10:05. And I do not see Thomas Bruce in the Zoom courtroom. Based on counsel's representations, he's not in the physical courtroom. And I know counsel just stepped out to call the hallway. It would appear that the defendant has failed to appear for the probable cause conference. Ms. Tepper, how would you like to proceed?
Your Honor, I would ask for a bench warrant in this matter.
Any comment, Mr. Goodrich, or have you had any contact with Mr. Bruce?
I have not had contact with Mr. Bruce.
All right, so due to the fail to appear for probable cause conference, the court will issue, this is an assaultive crime, one count of an assaultive crime. I will issue a bench warrant and bond forfeiture. What? That's, yeah, it was not without, it's not issued with a 48-hour hold. Anything else for the record in 24-03-294, Ms. Tepper?
No, Your Honor, thank you.
Mr. Goodrich?
No, Your Honor.
All right, thank you. Under the moniker of Catherine, can you please identify yourself? You'll have to unmute. Catherine?
Yes, I'm waiting for a case that was supposed to be at 9 for Calvin Thompson.
Yes. That case is to be at 9 o'clock. Are you a witness or are you just,
I am
I'm just identifying who's in the courtroom.
Yeah, no, I'm a foster parent of one of his children.
All right. All right. Stand by. Stand by, and we're going to call that case when everybody's ready. Mr. Thompson has 2 files with us today. So stand by. Thank you, Miss. Thank you. What's your last name, ma'am?
Vander Stel.
All right. You're all set. Thank you for your appearance.
Thank you.
So that's a witness, or somebody on standby.
I think she's just. Tony Austin.
I don't know if he's the gentleman in the cell or not.
I think I met you. Okay, there's Mr. Austin.
All right.
I do need to speak with him if I could get a breakout room.
Okay.
Thank you.
But we're not muted, just so.
Yeah. I don't know if I signed that.
To turn so.
I need Mr. Austin is who I need to be in the breakout room with.
Yeah, I go, I'm right here.
Yep, I just got in the wrong room apparently.
Yes, ma'am. Can you hear me?
I can, but hang on a minute, we're not in private yet.
Okay.
Ms. Schroeder, who did you want to see?
I wanted to see Mr. Austin. He is the gentleman right there right now.
On post 2?
Yes, visit 3. Yes, Your Honor.
Okay, I'm gonna move, so I'm gonna move you to room 3.
Okay.
And I'll move Mr. Austin, who is in post 2, visit 3 to room 3. in docket 1600231. That is People of the State of Michigan versus John Summers. Will the parties please introduce themselves to the record? Ms. Tepper.
Assistant Prosecutor Abigail Tepper, appearing on behalf of the people.
Mr. Wickman.
Good morning, Your Honor. Christopher Wickman on behalf of Mr. Summers, who is present and standing to my right in the courtroom.
And sir, you are John Summers, is that correct?
Yes.
All right, thank you. This time is set for a bond motion. Ms. Teppers, you're in possession of the bond motion filed by the Nichols Law Firm.
I received it this morning, Your Honor.
All right. And that you've had the opportunity to review it?
I did, sir.
All right. Motion for bond, Mr. Wickman. I've also received the motion for bond from the Nichols Law Firm, and I'm familiar with it now that I've reviewed it. Mr. Wickman, you may proceed.
Thank you, Your Honor. First, thank you to the court for allowing us to address this. Mr. Summers has been in jail a couple days. This is a probation violation. The court could absolutely continue to hold him. We're not asserting otherwise. We're asking the court to consider setting a bond with some probation-like conditions. This is, as the court reported, a 2016 case where we're here from the violation from 2017. The recommendation 7 years ago was revoked with some jail. Mr. Summers maintains he's not the same person he was back then. He's been in the area. He has one driving while license suspended. He's even made some changes significantly since then. There have been no other issues. This is a 93-day misdemeanor OWI first case. If the court wants to figure out if in fact Mr. Summers is a good candidate or has been rehabilitated or can be rehabilitated, I think this 8-day period prior to the next hearing would be a great time to figure that out. Or if the court is just going to say, you know what, we're just going to send you to jail. I think this would be a good trial period. Mr. Summers cannot drink. He has to abide by all conditions, test whatever the court wants him to do. He is, positively speaking, a great worker. Not everyone, they're his boss, actually. Mr. Jatinder Alawalia is present in the courtroom here, Your Honor, just standing up. He is a reputable local businessman and was in fact greeting court staff this morning for the clerk's office and things like that. He's willing to put his money where his mouth is, and his belief is in John, that John is going to take care of everything and post that bond as needed. That could be set in the amount of the outstanding fines and costs or some other amount. He will also be present to reinforce this court's orders on bond conditions and anything that is the case. Mr. Summers is not on a revoked license. His license could be in fact restored if the driving while license suspended is worked out next week. So I do believe that Mr. Summers could complete a term of probation and reinforce the changes in his life. And this 8-day period would be a good time for the court to find out if Mr. Summers is in fact rehabilitated or rehabilitatable, or if in fact this is going to be a case where the court is just going to put him in jail. But I think the 7-year period with minimal contact would be a consideration to give a low bond, either cash surety or 10% of conditions. Thank you, Your Honor.
Thank you. Ms. Tepper.
Your Honor, the people have no position on the bond motion or regards to probation and would leave it to your discretion.
All right. Well, I see the bond was set at and then remanded for the probation violation from 2017. Is that a fair statement, Mr. Wickman?
If the court is at, I believe it was a no bond once he was picked back.
It was picked once he was picked up. There was a remand.
Correct.
Right, and that was for the drunk driving probation. The initial bond was set at 3,500, 10%, and that was initially set by the same magistrate. So the magistrate who arraigned the individual also remanded for probation violation hearing. Is that your understanding?
My understanding, Your Honor, and I was not obviously present at that,
Right.
is that the magistrate felt that they had to have a no bond on this. I didn't get the impression from speaking with Mr. Nichols that it was an exercise of discretion of the remand, Your Honor. I thought that they felt that they were compelled to enter no bond in this matter.
Let me see, because
And I did think that direction came from the court to the magistrate, is my understanding, Your Honor, but that was from speaking with Mr. Nichols. I was not personally present.
that would have come from Judge. That's what I find this a little confusing, because it was placed on probation to Judge Alderson. I don't remember remanding on a 2017 case.
I agree that the history in this one is confusing.
That's what I'm trying to figure out.
And I would say, I don't know that the court is bound by anything
Right.
prior.
I agree. And it looks like Judge Alderson actually a PR bonded on July 25th, and it was a subsequent probation violation. But I'm just trying to figure out where the magistrate received information to remand on this, unless they just did it perfunctory, like it was a. But I do think that given the 7-year period of waiting, which is that's why we're here, Mr. Summers, is they lost track of you. Okay, they lost track of you, and they weren't sure where you were, and so you've been on probation violation for 7 years. Hence the remand, I think. But I think your counsel makes pretty good argument concerning your motion to reduce, and you've got your employer here. All right, which really adds to this whole dynamic, as far as I'm concerned. So I'm going to set bond at this time at 2,010%. Right. So bond will be set at, I'm setting it at 2,010%. I'm going to indicate as a part of this, no drinking, no alcohol, marijuana, or controlled substance without a prescription. I'm not going to I can order a GPS tether in the interim. I'm not going to do that because I think you are not the same person you were 7 years ago. All right. I think that's a fair statement. But I think your counsel said it right. This is kind of a trying out period. Okay. We're going to set this for hearing. This was set for hearing on November 15th.
Correct. Right.
Yeah. So you'll be in front of the court November 15th, and we'll kind of decide what to do then. But this is a little trial period, okay? Just to see, we'll set you on bond, we'll give you no drinking, no controlled substance, no marijuana without prescription. And then if you disappear on us again, Mr. Wickman comes up and, he filed a motion to reduce bond. And then I've kind of made up my mind, that you don't want to be on probation, So, but that in 2017, you were placed on probation because probation is another form of sentencing. All right. We're supposed to help people. Okay. Now you've taken this time to do some things that seem to be working. All right. So prove it to me. All right. Prove it to me by showing up next week. And that's my indication. Ms. Tepper, did you have anything else on this case?
No, Your Honor.
All right. So I'll set bond at 2,010%. We'll put as part of the bond, the indicated no alcohol, marijuana, controlled substance without a prescription. And then we will await the hearing on this for November 15th at 9:30 in front of myself. All right, sir? All right. Anything else for the record in docket 1600231, Ms. Tepper?
No, Your Honor. Thank you.
Mr. Wickman.
Thank you, Your Honor. Does he need to check in with probation or anything in the meantime, or just?
He probably should check in with probation to make sure he knows who he's reporting to his probation agent is. But he can do that once he's if he's released or if he makes bond, he can do that within that period.
Thank you very much.
Thank you. All right, that's all for the record. 1600231. And then.
Are you asking to come on in? If you want.
All right, let's go on Mr. Wilson. And then we'll go on, and then we're going to move. Are you ready on your case?
It'll be a waiver, Your Honor.
All right.
So my hope was to.
Let's go on your case, and then we'll go ahead.
Yeah. So keep.
I got Mr. Palmer jumping up like a But
Stand in first.
we are going to go on Mr. Wilson next. all
Okay,
right?
sounds good.
Let's go ahead and call on Mr. Ware.
Oh, I'm sorry. Never mind. It's not going to be a waiver now.
Okay.
Okay, we'll go on Mr. Wilson.
Yep.
I'll give you some time to speak to your client, Ms. Wanji. So, Mr. Wilson, you can come up here. Do you have these same issues in 55th?
Your Honor, I do not.
Well, welcome to 54A.
Welcome back. I was with Judge Buchanan last fall.
Yeah. Oh, were you?
I was.
Well, as you see, some things never change. We're on the record in docket 2402-523. That is People of the State of Michigan versus David Wilson. Will the parties please introduce themselves for the record? Ms. Tepper.
Assistant Prosecutor Abigail Tepper, appearing on behalf of the people.
All right, and Mr. Palmer.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of David Wilson, who stands to my right.
And sir, you are David Wayne Wilson, is that correct?
Yes, sir.
All right, thank you. This is the time is set for a sentencing in the matter. And Mr. Palmer, did you have the opportunity to go through the pre-sentence report with your client?
I did, Your Honor. I just have a couple of very minor changes.
Okay.
On the very front, it says detainers or pending charges, and then it lists a contempt hearing that was conducted, but that was back on October 24th at 8:30. So I don't know that it's still pending.
Okay.
So I just bring that. I guess maybe it qualifies under a detainer, although the court sort of gave him a warning, I think is the way I
All right,
characterize
so
that.
that I can place pending, or that was a warning. I remember that.
The other, I guess, concern I have, I just want to raise it to the court's attention. There is the last page is a probation recommendation sheet. Under conditions, it recommends that Mr. Wilson obtain or maintain employment. My concern there is that Mr. Wilson has been on Social Security disability since the age of 14. So that's what he's dealing with. So I would just ask that the court consider striking the obtain, maintain condition for probation.
All right, thank you. So I'll note I'll note that that's been in dispute on and for the reason that he's on Social Security disability. Anything else concerning the pre-sentence report, Mr. Palmer?
No, Your Honor, thank you.
Allocution, Mr. Palmer.
Thank you, Your Honor. I'm going to ask that the court follow the recommendation and sentence Mr. Wilson to a term of probation. I understand that there is some concern in the PSI, I guess, about his disconnect regarding what's going on here. But I certainly think in speaking with Mr. Wilson, he's accepted responsibility. He did enter a plea. He did not want to contest these charges. He admitted to his wrongdoing. And he is, I know, very remorseful. This was I think one of the issues that was at play here was that this is the victims were the adult daughter and her husband of my client's longtime girlfriend. So there was a sort of heated element certainly here in terms of a family dynamic and some wrongdoing by Mr. Wilson. It stemmed from an incident that had occurred the night before. Mr. Wilson admits that he did not handle that well, and he is certainly remorseful. I do think Mr. Wilson would be a good candidate for probation. I'd ask that the court follow that recommendation.
All right, Mr. Palmer, you understand the recommendation is probation for 12 months, but they're ordering 7 days up front.
I do see that, Judge. I guess there's a little bit confusing because
they've given 3 days credit, but then that leaves 7 days up front for jail.
I understand that. I would ask that the court forego the jail sentence and just place him on a straight term of probation.
All right.
What I would point out, and I didn't bring this up in terms of the correction to the PSI. At the time of the plea taking, there was a killabrew for no upfront jail. I guess technically that's
gone because he entered a bond violation.
Correct.
So, which is why I didn't bring that up, but I would point out that there is that issue. That is, the court may recall, the tether violations in this case were not actually contact with the victim. They were drive-throughs. So they were all instances where Mr. Wilson was in a car, he entered a restricted zone, and within, I think, a minute or two was back out of the restricted zone, which is why the court gave him the warning as opposed to, I think, I don't mean to imply what the court did, but that's why I think that the court gave him a warning as opposed to giving further sanctions. And so while I understand that the nature of that technically the Killebrew has been violated and is no longer in place, what I would point out is that he's not had contact with this individual or individuals, the protected people. He's not had wrongdoing other than these, as I say, these sort of coincidental drive-throughs, the restricted zone. And I think, and to be clear, it wasn't even as if he drove past that individual's house. What happened is he was going down, for example, at least one of them, I don't have them in front of me, at least one of them, he was going down a major artery. He was going down Saginaw. The restriction zone in this particular case is so large that it happened to catch him as he drove through Saginaw. I don't bring that as an excuse, but I'm just pointing that out.
Right. My concern is that he was given the warning for the September 1st, 15th, and 3rd violations, which he pled to on October 23rd. And then there was another violation on November 3rd, which was near the victim's work. That's my concern.
I understand that, Judge, and I saw that in there, but that was never, I don't have any information regarding that one. And it was not brought forward, I guess, as a bond violation. So I don't know how to address that, right, just because I don't know anything about it. It appears to me that it says zone near victim's work. It appears to me that it's another drive-through. And I did question my client about that. And I think the 3rd was this past Sunday. I did question my client about that. I do think there's at least an explanation there. I didn't offer that because there's not technically a bond violation for it before the court today.
All right. All right. Ms. Tepper, any position by the prosecutor's office on the judgment, on the sentencing?
Your Honor, I'd ask that you follow the recommendation by probation officer Baylor.
All right. Mr. Wilson, is there anything you'd like to say before the court passes the sentence?
No, sir.
All right. This is for the guilty plea for September 13, 2024 to stalking. There was at the time a Killebrew agreement about no upfront jail, but that there's been a violation concerning some of the no contact or the GPS provisions concerning that, and that would withdraw the Killebrew agreement. I'm indicating today that I'm going to follow the judgment of sentence at this time, and I'll explain to you why, Mr. Wilson. So this is for, it is ordered that you are to spend 10 days in jail beginning November 7th, that's today's date. Credits given for 3 days, so you'll serve 1 week in jail. I'm going to place you on probation for 12 months. We're going to do the fines and costs associated with this case. Fines would be $250. Costs would be $250. Crime victims' rights fee of $75. State minimum court cost fee of $50. Probation at $360. I'll give you a full term of that. So that's 500 plus 125 plus 360 is 985 total. You're placed on probation for 12 months. So the probation department may become, you should contact your probation agent to see who's available and who's going to be your probation agent. Fees are paid at $30 per month per probation for 12 months. There's no contact with the victims Eduardo Cerna Jr. and Chelsea Cerna, or be within 2,000 feet of wherever the victim lives, works, goes to school without consent of this court. no assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription, submit to random PBTs and urinalysis as directed, no bars or nightclubs, complete the following rehabilitative services, which would be moral recognition therapy and any substance abuse education and pay fees submitted by your probation officer. I will strike the obtain and maintain employment since you're on disability. So I'm going to strike that from the sentence. And I'm going to indicate that defendant is on disability at this time. Not purchase or possess firearms, ammunition, or weapons of any kind. And they're requesting a scram tether, and I'm going to place it on scram tether. All right. That is so that you're placed on GPS. So once you're released, they'll know where you are. All right. Is that a fair statement, Ms. Tepper?
No, no.
Is that Mr. Palmer? Is that a fair statement?
Yes, sir.
Okay. A scram tether is the tether place so that he will be always on monitor.
Your Honor, I was under the impression that the scram tether is for alcohol.
Oh, yeah, I think she's
Yeah, I
right.
think
Actually,
she's
I
right.
think it's a GPS tether, not a screen.
Yeah, I think you're right.
She's right.
Mention order to scram, and I don't know why. I just followed their recommendation. There may be something in the PSA.
I think we're going to order a GPS tether.
Can I say something, sir?
You had your opportunity to say something before. You can say something now if you'd like.
These people, I mean, I want to leave my house, sir. And, they tried to jump me, sir. All right. I got punched in my face, so they broke my $500 glasses, sir. And I mean, I went to their house the next morning, sir. All right, it's my stepdaughter that I do a lot for. And and I did bang on their door. And they called the police on me. Right, I never called the police on them. I'm the one that got socked in the face. Or I'm the one, when I went to jail, there was pictures of my face, messed up. Right, and I mean, I'm the one that got to be all on this and stuff because I banged on the door. Right, it's not right, sir. All right, that's all I have to say.
All right, thank you. You understand the no contact order with Eduardo Serna and Chelsea Serna?
Yep.
You understand that you are on GPS tether once you're released from jail and you're going to be monitored, all right, sir?
Yeah.
You understand that?
Yeah.
All right, I've looked at the criminal history in this matter, and your criminal history is...
That's 20-something years ago, sir.
Yeah,
I'm 50 years old.
Yeah,
these people were 20 years old, and so right at my house, they took a video of this for 20 minutes or so, trying to jump on me.
Right.
But it's okay.
I understand. You have two domestic violence on your record.
Well, I wonder why. Right.
Yeah,
At my own house, and stuff. They
it's-
disrespect me right at my own house.
Right. Well, call
That's
the...
okay what they did.
I think you should call the police.
fine.
Okay?
Oh,
So...
I should have. Well, no, their own mom. I've been with, her mom for 13 years.
Right.
And the mom didn't, call the police.
Right.
Right. That's fine, sir. Yeah.
All right, thank you.
Yeah.
Anything else towards the judgment of sentence, Ms. Tupper?
No, Your Honor, thank you.
Mr. Palmer?
No, Your Honor, thank you.
All right. I have moral recognition therapy. Oh, anger management's also been ordered by the probation department, and that'll be a part of the sentence. So anger management, moral recognition therapy, and substance abuse education placed on GPS tether for monitoring purposes in regards to as a part of probation. We should make this look okay. Okay. So I will, do you have any questions concerning the judgment of sentence, Mr. Wilson?
No.
All right, thank you. That's all for case 24-02523. You can go with security. Thank you for your appearance today.
Yeah.
Mr. Palmer,
Yes, ma'am.
do you mind handing me the record?
Your Honor, apparently there
Sorry?
is going to be a waiver.
Yeah. Where it prints out.
Oh.
Thank you, Mr. Palmer.
Sure, no problem.
I think I.
Mr. Milks is more.
Yeah.
That's
better, that's
Sorry, I'm just trying
To my helper.
Got a lot going on.
This came up for
Okay, one second.
It's all good. I only got a week. That's all right.
Oh, yeah.
Yeah, they got away with what they got to do, though, didn't they? I'm the one that got socked in the face. Shut up, Ariana. Don't say that.
All right. Mr. Pfeiffer?
Did she just make a threat? That's great. We're ready now to handle the waiver on DeAndre Ware, Your Honor.
On Mr. Ware?
Yep, so you can get out of here and go to work.
So that's docket, let's see. 240247. All right, so we're on the record in a docket 240247. That's People of the State of Michigan versus DeAndre Ware. Will the parties please introduce themselves for the record? Mr. Pfeiffer.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Ms. Wanji.
Good morning, Your Honor. I'm Daniel Wanji for Mr. Ware, who's by my side at the council table.
Thank you. And sir, you are DeAndre Ware, is that correct?
Yes, sir.
Thank you. This is the time set for preliminary examination day. Mr. Pfeiffer, how are we proceeding?
Your Honor, it's my understanding that we'll be doing an unconditional waiver of the examination today.
That's correct, Your Honor.
All right. Ms. Wanji, may I inquire of your client of the waiver of the preliminary examination?
You may, Your Honor.
All right. All right, Mr. Ware, you understand you have the right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Melanie Wanji. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding, it is your wish today to waive your right to a preliminary examination, have negotiations continue in circuit court where this case will proceed in circuit court. Is it your wish today to waive your right to a preliminary examination?
Yes, sir.
Mr. Pfeiffer, do the people also waive their right to a preliminary examination?
Yes, Your Honor.
All right. I find the waiver of the preliminary examination be knowing, voluntarily, and accurately made. And I will provide the bind over documentation for signature purposes. And Mr. Pfeiffer will draft you.
Thank you.
Okay.
Ms. Wanji. Thank you so much. So I am in possession of the bind over documentation on 240247. Will indicate the examination has been waived on today's date. That is November 7th, 2024. Is there anything else before the court signs the bind over documentation, Mr. Pfeiffer?
No, Your Honor.
Ms. Wanji.
Nothing or nothing.
All right, I'll sign the bind over documentation. And Mr. Ware, you'll get your next date in circuit court where the case is proceeding. You'll get your next date from your attorney, Ms. Wanji. All right, sir?
Okay, thank you.
All right, you should be all set. Thank you for your appearance today.
Yeah.
Thank you, Ms. Wanji.